Gabrielle, welcome to the show.
Thank you. Thank you for having me.
Yeah, grateful to have you here to tell your story, in which we have a lot of listeners from ECI, SCI, some of the surrounding um, uh, correctional facilities in our area, avid listeners to the show, and hopefully your story can resonate and travel where it can get to the right people, where we can uh, get a headway on what's going on with your husband, and hopefully it'll be the catalyst to help others as well, because I know there's a lot of others who are unjustly incarcerated, and hopefully your story and what you guys are going through not only helps your situation but others as well.
Absolutely. Absolutely.
Yep. So first off, just tell us what's going on, the situation with your husband, and just to give our listeners a little background on what's going on with his situation now.
Okay. Absolutely. Well, my husband, his name is Joseph Edwards. He has been incarcerated for going on 6 years now for felony murder. And a lot of people, to be honest, a lot of people don't know what felony murder is. To my surprise, a lot of people don't know. I've asked a few people, hey, you know what felony murder is? And the common answer that I usually get is, well, yeah, if you kill someone, that's a felony, and that's felony murder. That's not right. That's not correct. Felony murder is a death that occurs in the commission of a felony, usually a dangerous felony like burglary or robbery. And the dangers of this law is that any participants involved in that felony can be charged and found guilty of murder, even if they weren't the ones that killed anyone. And that's a scary thing. That's a very scary thing. And so my husband, like I said, he's been incarcerated for 16 years now. He was found. He went through a 5-day trial. Excuse me if I sound a little raspy. I'm trying to get over this cold, but it's currently winning.
Oh, you good? You good?
But so my husband went through a 5-day trial, and he was ultimately found not guilty of first-degree premeditated murder. He was found not guilty of robbery, but found guilty of felony murder. Now, robbery was the only underlying felony that he was charged with that could uphold a felony murder conviction, and he was found not guilty of that. So that right there is an injustice on its own, because if felony murder is murder in the commission of a felony, and he's found not guilty of that felony, then how is he found guilty of felony murder, right?
Right.
So, like I said, he went to a 5-day trial, and throughout this 5-day trial, attempt robbery was never, ever spoke of. So after the 5-day trial, the verdict came down: guilty of felony murder, not guilty of armed robbery, not guilty of first-degree murder. So 84 days after his trial, after the jury was discharged from duty, 84 days later, he has a sentencing hearing. At his sentencing hearing, that's when his defense attorney asked for a motion for a new trial due to the fact that his client was found not guilty of the only charged felony that could uphold a felony murder conviction. So the judge then says, well, you're right. State, what's your argument? The state then deposits a new theory that, well, maybe, and this is verbatim, maybe the jury believed that he attempted to rob, right? He was never, ever charged with attempt robbery. Attempt robbery was never mentioned throughout his 5-day trial. There was no evidence produced on attempt robbery. It was never argued. We never got a chance to defend against attempt robbery because it was never on his verdict sheet. It was never a charge that was on his indictment. It was never, ever spoke about throughout a 5-day trial. Until 84 days later at sentencing, when his lawyer is asking to set aside the verdict, Now it's maybe the jury believed he attempted to rob.
Yeah, and so I don't get how you can come up with hypotheticals in a situation like that. You know what I mean?
I don't know either. I don't know. I don't know either. But and that's what happened. So he was then charged. He was then sentenced to life in prison for felony murder.
Wow.
I want to reiterate that if felony murder is a death that occurs in the commission of a felony, because he was found not guilty of first-degree premeditated murder.
Yeah, the felony murder. It sounds like a crutch. If we can't get you on these, we got this.
It's definitely a crutch. It's definitely a crutch, and it just goes to show how this rule can be manipulated and really manipulated to fit the prosecution. You know, and it's not right. It's not right at all, and it's unjust, and it should not be on the books. You know, it's been said that one of the basic principles of a fair legal system is that people should be held responsible for the crimes that they commit, not the crimes committed of others, you know? And that's basically what this felony murder rule allows. It allows one to be convicted and held responsible for another person's actions. And it's not right. And I kind of want to give, I want to give an example, because like I said, a lot of people don't really fully understand, you know, what this felony murder rule is. And I kind of want to give an example, if that's okay.
Yeah, go ahead.
Okay. So, and this example actually comes from an article in the Maryland Daily Record that was published June 30th, 2022. And it's titled, "It's Time to Abolish Felony Murder in Maryland." And this article talks about a 20-year-old kid. And I say kid, and I know I said he's 20 years old, but I say kid because there is studies on brain science and brain development that prove that the brain is not fully developed and matured 25. Until you reach about the age of 25. Yeah. So this 20-year-old is at a party, and he learns that his friends want to rob a local drug dealer. So he lends them his car. After giving them the keys, he goes to sleep. So in the commission of this robbery, someone accidentally dies. So now this 20-year-old, he's not charged as an accessory to the crime, but he's charged with felony murder and is currently serving a life sentence in prison.
Wow.
And that's just it's beyond me. This is someone who was not even present at the time of the crime, wasn't the actual killer, and had no intent or even no knowledge that anyone was going to get hurt. But he is serving a life sentence in prison. And like I said, it just goes to show how unjust this law really is. And then in my husband's case, it's just more just like they're not even following the rules of the law. Because like I say, and I know I sound like a broken record, but it's beyond me that if felony murder is murder in the commission of a felony and you find him not guilty of that felony, then how is it felony murder?
Yeah, it's almost like double jeopardy within the same trial.
Exactly.
You know what I mean? Like, how can you double back? Oh, you beat this and you're not found guilty of this, not found guilty of that, but you found guilty of this, which it doesn't make sense. And again, what you were saying earlier, I mean, the time should fit the crime. You know, and this is definitely not the case. And then also the case you just mentioned too about the article that you just read about as well. We're gonna go to a song real quick, and then we're gonna come right back to you. You said that you would be able to get your husband on as well, right?
Yeah, he's actually going to call in a couple minutes, and I can get him on.
Okay, yeah, because we like to talk to him as well, and he can go ahead and share his story as much as
Okay.
he can.
Absolutely. I appreciate that.
Because you guys are still, because you guys just went up for an appeal last week, right?
Yeah, actually, so we filed a motion to correct an illegal sentence, and that was last week, and we were granted an oral argument on that. So his attorney went in and pled his case, and the state was there, and of course, they said what they said, but we're still waiting. We're waiting on a decision now.
He was acquitted of the only underlying felony for which he was charged, which was robbery with
conspiracy to commit robbery.
Yes, Your Honor. He was acquitted of those. He was acquitted of the robbery with a dangerous weapon. He was acquitted of the conspiracies. He was acquitted of the first-degree premeditated murder. There were some additional robbery charges with additional victims. He was acquitted of those. He was convicted only of the first-degree felony murder and the gun charge that was associated with that. As a result, the verdict should not stand.
So those are inconsistent verdicts.
They're inconsistent verdicts, but that is not the sum total of all of the arguments, because it also, the way the state put forth their argument, both at the sentencing and later on direct appeal, it wasn't even, attempt was never even mentioned as a reason for, as basically an underlying felony, an attempted robbery. There was no attempt jury instruction given, though there was, the court did read basically what felony murder was, and very clearly stated that robbery with a dangerous weapon was the only charge that was the underlying felony. Read the instruction with the brackets that said commit or attempt to commit, and the state tended to hang its hat on that, did not even mention attempted robbery until 84 days after the jury returned its verdict at the sentencing, when defense counsel argued a motion for a new trial because of the inconsistent verdicts. The state then posited this new theory about attempted robbery, which had not been charged, had not been argued, no evidence had been adduced, no motion for judgment of acquittal addressed it. It was not part of the prosecution or the defense. No jury instruction was given. And then the state brought it up when the conviction was challenged at the sentencing. This amounted to basically a constructive constructive amendment of the indictment, obviously much longer in time than the court would, or than the state would have the ability or the jurisdiction to amend an indictment.
Counsel, but then your client filed an appeal to the Court of Special Appeals, and the Appellate Court of Maryland, and the Appellate Court of Maryland decided that the argument that there was an inconsistent verdict was waived, and that's no petition for certiorari was granted, and so isn't that the final adjudication of that issue?
It is not, Your Honor, because it was not raised as an illegal sentence. And an illegal sentence can be corrected at any time. In fact, Johnson v. State, 427 Maryland 356, a 2012 case, the Supreme Court of Maryland vacated an illegal sentence for a crime for which the defendant in that case had never been indicted. That was an assault with intent to murder. It's very similar to this.
No, it's not, because the Johnson case involved a conviction of a crime that the defendant was never charged with in the first place. And here the defendant was certainly charged with murder, and the jury was instructed on both the first-degree murder and the felony murder for first-degree murder. And the problem with this case is not that there was a lack of sufficient evidence for the murder conviction. The problem was that there was the jury's verdict, by finding him guilty under the felony murder rule, but acquitting him of the underlying felonies, there's an inconsistency there. That's different from the situation where a person is accidentally sentenced for a crime that he or she was never charged with in the first place, which actually comes up more frequently than you might think. To me, the classic definition of an illegal verdict for the purposes of the rule that we're talking about is the Cheney versus illegal sentences. Is Judge Wilmer's articulation of it in Cheney versus State. We have consistently defined this category of a legal sentence, that is cognizable under Rule the subsection of the rule we're talking about, to be limited to situations in which the illegality inheres in the sentence itself. Either there's been no conviction warranting any sentence, or that the sentence is not a permitted one under the conviction that was actually imposed. And how does this case fit into that?
Well, this case, it's different to some degree. It's not identical to Johnson because that was an uncharged, but in this case, attempted robbery was not charged. No felonies were charged except for, no felonies that would be considered an underlying felony for under the felony murder statute were charged other than robbery with a dangerous weapon, of which the defendant was expressly acquitted of that. So felony murder is a bit different than other inconsistent verdicts. And in this particular case, some of the other case law, I would say Carlini versus State and Brightwell versus State, that if there is not a conviction that would warrant any sentence for the particular offense, or the sentence, which basically echoes Cheney, the sentence is not a permitted one for the conviction. Here, there's no conviction that would warrant any sentence because of the fact that he should not have been convicted of felony murder because he was acquitted of the only underlying felony which he was charged.
Isn't it, the state cites Pitts for the proposition that a defendant must object to the inconsistent verdict before the jury's discharged. I saw that you did refer to Pitts briefly in your reply brief, but you didn't attempt to distinguish it. Do you have any basis to distinguish Pitts?
Yes, Your Honor. Pitts addressed the case of a defendant who was convicted of first-degree intent to kill, premeditated murder, and was acquitted of second-degree murder of the same victim, which was an inconsistent verdict, but it was different from the type, and perhaps I should have elaborated more in my reply brief about why it's distinguishable, because in Pitts, we're talking about an evidentiary situation where it involved an intent to kill murder of one victim, whereas here Mr. Edwards was actually acquitted of the intent to kill, premeditated murder, and the attempted murder of the other victim and the robberies of the other victims, and was only convicted of the felony murder of the one victim for which he was also acquitted of the first-degree felony murder. Felony murder in itself, it's an unusual animal because what felony murder requires in terms of its elements are only the proof of the very specific underlying felony, which the essential ingredient, that's the Farrell v. State case, a 1988 case, must prove the elements of the felony and that the death exists, the death happened. Other than the death happening and being connected to the felony, the elements are just the elements of the felony. So it's a more, I guess I would say, egregious type of disparity in terms of the type of verdict than in Pitts.
More egregious where a jury finds premeditation for first-degree murder but finds no intent to kill for second-degree murder. You think that's a significant difference from this case?
That's a good point, Your Honor. It is, and that's definitely an inconsistent verdict too. But I just think because we're talking specifically about felony murder is an unusual crime because it's statutory in nature in terms of like a common law type of crime, like it's wrong to kill. We're talking about if someone dies in the course of the commission of a felony, like a robbery, that it's a statutorily prescribed murder, that the accomplices are also guilty of felony murder. So while I would say that they're both inconsistent verdicts, it's different because of it being a statutorily prescribed type of murder.
Wouldn't the policy be the same in either one? In Pitts, if requested, the trial judge would say to the jury, these are inconsistent, you need to go back and deliberate and straighten this first-degree murder out and second-degree murder acquittal out. And here, had it been requested, the trial judge would have been obligated to say, you can't have felony murder without the underlying felony. I'm going to send you back, and we're going to get this worked out. And that's the policy reason to object before jury discharge, right?
That is true, and that, of course, came forward in Gibbons. And if you look at the timeline of this particular case, the verdict was before Price. The Price case came out while this case was pending on direct appeal, but before the brief, and Price was stated in the brief on direct appeal. So the inconsistent verdict issue applies to this case. He doesn't have the retroactivity problem. Gibbons came out several years later, and Gibbons adopted Judge Harrell's concurring opinion in Price. And so while it did seem a bit murky at the time, a lot of lawyers didn't quite understand when to object and how to object, and now everyone knows or should know when to do that before the jury is hearkened. But in this particular case, and there's case law prior to the instant case, Smith versus State, 412 Maryland 150, 2009, that a lesser included offense must be submitted to the jury to be considered by the jury, and a person may not be convicted of an uncharged lesser included offense unless the parties are given an opportunity to present argument. And there's also the Jenkins case, Jenkins v. State, 59 Maryland Appellate 612, 1986, that the court should correct a defective verdict even if the trial counsel doesn't object. And so that was the law at the time of Mr. Edwards' case. So it's a bit murky because of it being pre-Price and then post-Price on appeal and then pre-Givens. Also, going back to the Pitts case, another issue there is that Judge Moylan was talking about there being a defective jury instruction issue, and I think that's a good part of why the defendant was convicted of the first degree but not the second degree, because the court's erroneous instruction confounded the jury, and Judge Moylan concluded that while a motion to correct a legal sentence is cognizable at any time, there's no latches or there's no statute of limitations, that certain things, for example, an issue about an erroneous jury instruction should be raised on direct appeal in a timely manner or it's waived. And so that case was sort of trying to bootstrap that issue into the illegal sentence issue, where here we have more of a pure illegal sentence issue because of the fact that the sentence, he couldn't stand legitimately convicted of first-degree felony murder while being acquitted of the second-degree murder. And the state basically, this whole attempt argument was a bit of a red herring. The state came up with this, again, 84 days later at the sentencing, and that, if accepted, would amount to a constructive indictment of the amendment. I addressed that a little bit in the reply brief in terms of when I believe it was the Brown case, when an indictment can be amended, and the reasoning why it cannot be amended. Yes, it was Brown versus State, 1979. That Maryland Rule 4204 provides the court may permit the amendment of a charging document prior to the verdict, but if it changes the character of the offense, the consent of the parties is required. Here it was constructively amended at the sentencing, basically as a counter to the defense counsel's argument about the inconsistent verdicts. And then we get into Jones v. State, that the failure to orally announce or hearken the jury removed the court's power to convict and sentence. He was never convicted of the of the charge of attempted robbery, only acquitted of all the robbery with a dangerous weapon charges, and there was no instruction given as to attempt. Therefore, the sentence is, the conviction is a nullity, and therefore the sentence is a nullity, and it is cognizable under Maryland Rule 4345 to be corrected as an illegal sentence. Thank you.
So,
Any questions?
and one more thing that really, so last year, in the middle of last year, we actually filed a motion to reopen his post-conviction.
Okay.
And we were granted a hearing on that. So middle of last year, I want to say April, May of last year, we had that hearing. And one thing that really stuck out to me, and ultimately all of his issues were denied. He was not granted a reopen. But one thing that really stuck out to me and what the judge said is, well, Mr. Edwards, the prosecution doesn't have to find that you were the actual killer. They just have to prove that you participated in that underlying felony. Threw me completely left, because I'm now thinking, okay, then why are we sitting here 16 years later, and why is he still in prison 16 years later when you know, court knows, prosecution knows, the jury knows that he was found not guilty of that underlying felony, and you're saying it out of your mouth that in order to be convicted of this, you have to be found guilty of the underlying felony, in which he was not. See, Joseph?
Hello? Yeah.
All right, peace, bro. What's
Hello?
good? Hey, bro.
How you doing?
Good, man. Good, man. Welcome to the show, man. I'm glad we can get you on, man. We let the listeners, your wife let the listeners know a little bit what's going on with your case, which is, unfortunate and it's a very unjust case, of course, obviously. And with us, with our platform, we're trying to, reach a mass of people and get the word out there and get it out there, what's going on with your case, and also reaching others who may have cases, maybe not as extreme as yours, but, they have unjust situations as well. So, I mean, I know, because you're still, I guess you're in legally, I don't want you to get putting them out there that you don't want out there, but just share with the people what it is you want to get out there as far as your case and what you've been dealing with for the last 16 years.
Oh, okay. How you doing? First of all, my name is Joseph Edwards. I'm convicted of felony murder, first-degree felony murder. I'm pretty sure you probably have already had a briefing on what felony murder is. So as you know, I was put on trial for felony murder, and my underlying felony was armed robbery. So the theory of the case was that me and a crew came to this place this night to rob, and during this robbery, someone lost their life, and they said that is felony murder. However, I was put on trial 5 days for underlying felony of armed robbery and felony murder. I was acquitted at the end of the trial of armed robbery. So I didn't have an underlying felony to support the felony murder conviction. I was also acquitted of committing the actual murder. I was acquitted of first-degree murder as well. 84 days later, after I was convicted, the state deposited a theory of attempted robbery. So my lawyer made an objection. He didn't object at trial when the verdict was rendered. So he finally, I guess, realized that the verdict was inconsistent and repugnant at my sentencing hearing. And he made an objection. He said, Your Honor, I object. I would like to have the felony murder conviction set aside. My client doesn't have an underlying felony. He doesn't have anything to support the felony murder conviction. And he was acquitted of the actual murder, which is first-degree murder. And the judge said, well, state, do you have a rebuttal? And the state said, sure. The state said, well, maybe the jury believes he attempted to rob. And I've been sitting here for 16 years for maybe the jury believes I attempted to rob. Mm-hmm. Now, the state never argued a theory of attempted robbery at my trial. No one at my trial testified to an attempted robbery. There was no jury instruction as to attempted robbery. Attempted robbery was not on my verdict sheet. I wasn't charged with attempted robbery, nor was I indicted with attempted robbery. The word is not even in the transcripts. Now, I have 1,000 pages of transcripts. Of course, I had a 5-day trial. It's a very lengthy transcript. The word attempted robbery is not even present in the transcript. And so I argued this on appeal, and argued that the trial counsel was ineffective for failing to object when the verdict was rendered. And he argued on appeal that, well, why would I object and ask for an attempt robbery instruction? That's not what you're charged with. So the state came back, they denied the appeal and said that, well, the court finds adequate proof of an attempt to rob, and a jury could have found the same. So, of course, the argument is that, okay, if a jury could have found the same, then shouldn't I have had an instruction, or shouldn't someone have at least had to argue this at trial? And she said the judge's reply was, the Honorable Judge Amy Bergoni, her reply was that, well, the jury was instructed on attempted murder, and they was instructed on armed robbery. So they knew what attempted armed robbery was. Attempted robbery was not an enumerated charge in this case. Therefore, no instruction was given. And I've been fighting it since, and it's hard to get relief. And it's like it was no way for me to defend the attempted robbery charge. So I've been sitting here since.
Yeah, and I'm curious as far as your lawyer on this point when that, because it seemed like to me they convict you on a hypothetical, maybe like that makes no sense at all. So at that point when that was given down, I guess by the judge or whatever, what was your lawyer's reaction to that?
Oh man, I was lost. The only thing I could think of was don't I at least get a chance to finish that trial?
Right.
I was confused, and I didn't understand like how did this charge come about?
Right.
It was 84 days later after the jury was discharged and dismissed. It was never argued to a jury. Like I said, there was no instructions or it wasn't on the verdict sheet, so I didn't even know that I was defended. I didn't even know I was on trial for that. And obviously the lawyer didn't either, according to his testimony at the hearing.
Gotcha.
So no one knew I was on trial for this, but because of felony murder, in order to be convicted of felony murder, the jury has to find that the defendant committed or attempted to commit an underlying felony. And there's brackets in the instruction. And if you use the attempt bracket, if a person is charged with attempt, it says immediately following the instruction. The attempt bracket, there should be an instruction given on what it is. And in my case, none of that happened, and I've been it's been hard. And I've been trying to argue it, and I guess it's been pushed under the umbrella of an inconsistent verdict. I've argued that the indictment was constructively amended, and I haven't gotten any relief. The charge is very cruel and it's unjust. It's disingenuous with the law. We've been fighting, and despite the injustices, man, and despite the hardships that I endured throughout this process, I still maintain and I still was focused and striving. I accomplished things in prison. I've been locked up for 16 years. I've been infraction free. I haven't had an infraction. I've been in maximum security prison. Wow. I've created and founded 2 successful youth programs that was adopted by DPSCS. On July 25th, 2017, they was adopted into legitimacy. And they ran in the current Supermax 2 prison in the state of Maryland. It's North Branch Correctional Institution. And they're still being ran there today, currently. I'm also the lead peer here in JCI of the most successful and the hugest, the largest peer program in the state, peer recovery specialist.
Man.
And two college degrees, and completed every self-help program that was provided for me.
Salute,
like
man.
Nothing.
Salute to you, brother. Salute to you, man. And that should go a long way for helping your case too, because you're not in there being a knucklehead, not wilding out. You unfortunately you've been in there for that time, but you've made wise choices with that time that you've had in there, and to come out and be a productive citizen. That's crazy to me, man. That alone should mean a lot to help get you up out of there for sure.
Yeah. And I'm still working. I'm still fighting. I'm still putting the work in, man. So it's hard.
Yeah.
I'm not gonna lie, man. It's hard, man.
16 years, man. That's a long time, man. Down for charges like this that I just can't believe it's stuck. It's unbelievable, man. And unfortunately, like the brother Joseph and many others have been wrongly convicted. You know, the time and the crime does not match. And to bring frivolous hypotheticals to the conviction and use that and it worked. I mean, that's just unbelievable to me. Unbelievable to me, man. Look, again, Joseph, anything else you want to let the people know before we let you go, bro?
Oh, no, that's it, bro.
Okay.
That's it.
Well,
I appreciate the time, man.
yeah, we'll appreciate your time.
Hashtag abolish felony murder in Maryland, you know.
Okay, say that again. What is it again?
I said hashtag abolish felony murder in Maryland.
Okay, my man. Yes, indeed. Yes, indeed, man. We appreciate your time, man, and hold your head. Keep doing what you're doing, man.
All right, thanks, brother. Thank you for your time.
No doubt, no doubt. Peace to you, man. All right. All right, Gabrielle, anything else you want to let the people know before we let you go?
No, that's pretty much it. You know, it's just I really feel like it's, and even though we're working, you know, to get this felony murder rule off the books, I feel like it's important for you know, parents, guardians, you know, siblings, you know, especially older siblings, to let these young people know, you know, the dangers of this felony murder rule, you know, the dangers and, you know, how important it is to choose your friends wisely and, you know, make good decisions and, you know, just kind of be aware of your surroundings and not put yourself in situations, you know, that could ultimately land you in prison for life, you know?
Yeah.
So, no, that's pretty much it. And I really appreciate your time. And I thank you.
You're welcome. You're welcome. Hold your head as well. I mean, shoot, it's part of you. You're in there as well. You know, that's your heart in there. So,
absolutely. I've been in this for a long time. Me and Joseph have been together since we were kids. I'm 33 now. And before he went to prison, and he's been in there for 16 years. So it's been a long journey. It's been a long fight. But, you know, as long as I have breath in me and as long as I have a voice, I'm going to use it because, you know, and not just, you know, for his sake, but for the sake of all, because this rule is not right. This law is not right, and it needs to go.
Yeah,
so,
definitely.
Yeah.
Yeah. But hold your head, and you know, we'll continue to be in touch, and we'll be a voice for you. So whenever you know things progress and move along, hop right back on and let the people know what's going on.
Thank you so much. I appreciate it. You have a good evening.
Welcome. You too. All right.
Thank you. Bye-bye.